What Donald Trump did in the past, and what the Supreme Court is deciding now, crossed a line that Congress and lower courts had hoped would remain clearly defined. And when that line was questioned, Supreme Court did not hesitate. They responded with legal scrutiny, constitutional review, and institutional. For years now, there had been signals, not official rulings, not formal judgments, just legal challenges and academic warnings that presidential tariff authority was heading toward a constitutional test.
Donald Trump had been assertive, yes, but he had also been consistent in his use of emergency powers. His moves followed a certain pattern, a pattern of acting first and defending later.
Almost a pattern of testing legal boundaries. But what set off concern in Washington and legal circles this time was that the pattern stopped. No new tariffs, no new announcements, no new executive actions. Experts who monitor trade law and executive authority know the indicators. The pause in policy changes, the sudden increase in court filings, the quiet coordination between federal agencies. Whenever a policy environment goes quiet, it often means something important is about to be decided. Early this year, Supreme Court filings revealed what legal scholars described as a direct constitutional question, including challenges that had not been fully addressed in decades. These are the kinds of cases the Supreme Court only accepts when they are signaling something very specific: a need for clarification, a need for limits, or a need for confirmation of authority. Observers didn't know which category this case would fall into, or whether it would touch all three. But what they did know was that the court was reviewing how far presidential power extends. And when the Supreme Court shifts its attention to executive authority, even by a narrow margin, the entire government pays attention. The response issued by the Supreme Court was not routine. It was not symbolic. It was not procedural housekeeping. It was deliberate. Legal analysts, after closed-door conferences, described the case as consequential, far-reaching, and, perhaps most importantly, defining for future presidents. But legal authority only works if boundaries are respected, and the court made clear it would not rush. In fact, its response was among the most carefully measured we've seen in modern trade law cases. Here's what we know. Within weeks of accepting the case, the court requested expanded briefs. These were not ordinary briefs. These were historical, constitutional, and economic analyses, the kind the court requests only when it is preparing to set precedent. Tonight, court documents confirm that the Supreme Court is reviewing whether Trump's use of emergency powers to impose tariffs exceeded what Congress intended. The court acted before any future president could repeat the same approach without scrutiny. They reviewed trade tariffs on multiple countries, national emergency justifications, and the interpretation of decades-old statutes. In other words, the court focused on the legal mechanism, not the political motivation. This is what made the case urgent. Trump's tariff strategy wasn't just symbolic, it was legally actionable. It represented the kind of action that could expand executive authority permanently if left unexamined. And the court, understanding that, responded with structure. They didn't attack motives. They didn't rule emotionally. They focused on constitutional alignment. Here's where the story becomes even more significant. Legal scholars now believe Trump's tariff strategy tested the elasticity of executive power. After years of congressional gridlock, Trump wanted to see whether the system would push back. Instead of silence, the Supreme Court responded with process, discipline, and clarity. The response was so measured, so legally grounded, that even critics acknowledged its seriousness. You don't get the Supreme Court's full attention easily. But this case did. Constitutional analysts describe the move as a boundary test, a way to determine how far a president could act alone. But the court proved it remains both independent and institutional. Its actions were not just careful, they were precise. That precision matters because it shows the court is not passive. It is actively defining limits. As filings continued throughout the months, we learned more about the scope of the court's review. Trade lawyers examined tariff impacts. Economists evaluated market consequences. Historians reviewed past emergency powers. This wasn't just legal review. This wasn't just trade law. This was constitutional governance. And constitutional governance is the one thing unchecked authority struggles to survive. For every expansion of power, the court has historically countered with definition. Remember, Past presidents assumed emergency powers would go unquestioned. They believed courts would defer. They believed Congress would remain divided. They believed precedent would protect them. But history shows the opposite. Courts eventually intervene. Limits eventually appear. Authority eventually requires clarity, and that's what is happening now. What makes this moment so important and so delicate is that this case arrives during intense political pressure. Some want broader presidential authority. Some want tighter congressional control. Some want economic certainty. Some want constitutional restraint. The system is balancing all of this at once. And when leaders act under pressure, courts exist to slow things down, not to punish, not to reward, but to stabilize. The Supreme Court's decision to hear this case, now widely reported, signals that it is not willing to allow unchecked expansion. Officials stated that the use of emergency powers must be consistent with legislative intent. That is legal language for presidents do not act alone forever. You don't hear that tone from the court unless the stakes are real. Trump has publicly stated that limiting tariff authority could create economic complications. He said presidents need flexibility. He said trade requires speed. He said delays create uncertainty. These are not casual remarks. They reflect how high the stakes are. What makes this more complex is that this case is not isolated. Alongside it, other courts are reviewing executive actions. Congress is debating trade authority. Future administrations are watching closely. When multiple institutions focus on the same question, it means change is coming. Analysts now see several outcomes. 1, the court could limit emergency tariff authority. 2, it could uphold it with restrictions. 3, it could redefine congressional oversight. What matters is that the decision will shape future presidents, not just past ones. And today, the court chose deliberation over speed. Constitutional balance. The president wants flexibility. The court wants structure. Congress wants relevance. This is how systems correct themselves. Sources say the court is carefully reviewing historical records and economic data. They say the ruling will be narrow but powerful. And they say the decision is likely part of a broader effort to clarify authority. The response so far, careful, structured, and methodical, sends a message the system is working. As the weeks go on, more details will emerge about what this case will ultimately decide. But what we know is this: the court's review was timely. It clarified uncertainty. It reinforced balance. What happens next depends on the ruling. If authority is limited, history will remember restraint. If authority is upheld, it will come with definition. Either way, the system has shown it is ready. And tonight, for the first time in years, executive authority appears to be under careful review. Washington is quiet, too quiet. And when the system is quiet, it is thinking. Because tonight, the lesson is familiar. Power has limits. Authority requires accountability. And the Constitution still decides this story is far from over. But tonight, one thing is clear. The Supreme Court is watching. The precedent will matter. And the balance of power remains intact. We'll be here, explaining every step as it unfolds. The Supreme Court is watching. The precedent will matter. And the balance of power remains intact. We'll be here, explaining every step as it unfolds. But what happens after a court begins watching is often more consequential than the watching itself. Because once the Supreme Court takes hold of a question, it rarely lets go without reshaping the legal landscape around it. This is the stage most Americans never see. Not headlines, not oral arguments, but deliberation. Behind closed doors, justices debate intent, history, and consequence. They don't ask what is popular. They ask what is permitted. And more importantly, what is sustainable. This case forces the court to confront a question that has lingered for decades. How much authority can a president claim in the name of emergency, and for how long? If emergency powers can justify sweeping economic action without clear limits, then emergencies stop being exceptions. They become tools. And tools, once normalized, are rarely surrendered. That is why this moment matters beyond trade, beyond Donald Trump, beyond tariffs. It speaks to how future presidents, Republican or Democrat, will act when Congress is divided and pressure is high. Will they negotiate, or will they declare urgency and move alone? The court understands this isn't about one administration. It's about the rule book itself. If the court draws a firm boundary, presidents will be forced back toward Congress. If it draws a flexible one, Congress may find its authority further diluted. And if it avoids the question altogether, ambiguity becomes the new precedent. None of those outcomes are neutral. That's why the justices are moving slowly, why their questions are precise, why their language, even now, is restrained. Because once this decision is written, it will be cited for decades. Law schools will teach it, lawyers will invoke it, presidents will test it. And long after today's politics fade, this ruling will still be shaping power. There is also an international dimension few are discussing. Global markets are watching. Trade partners are watching. They want to know whether U.S. trade policy is anchored in institutions or subject to unilateral shifts. Stability matters. Predictability matters. And the court knows that legal clarity can calm more markets than any press release. For now, everything is paused, not frozen, but held in deliberation, held in precedent, held in the careful hands of a system designed to slow momentum when momentum becomes dangerous. This is not drama. This is governance. And governance is rarely loud when it is functioning correctly. So as Washington stays quiet, understand what that quiet represents. Not confusion, not weakness, but consideration. Because the most powerful decisions in American history are often made without spectacle. When the ruling comes, it will not announce itself with urgency. It will arrive measured, footnoted, carefully reasoned. And when it does, it will tell us something fundamental, whether emergency power remains an exception or becomes a habit. Until then, the system waits. The branches watch one another. And the Constitution, as it always has, sits at the center, demanding justification. This case will end. The precedent will remain. And the balance it defines will shape every president who follows. That is why this moment matters. That is why the silence matters. And that is why, when the decision finally arrives, it won't just close a case. It will draw a line.